Hello, I'm Tom Gosling, Executive Fellow at the European Corporate Governance Institute, and I'm here today with Umakanth Varottil, Professor of Law at the National University of Singapore, to discuss his paper Climate-Related Shareholder Activism as Corporate Democracy, a call to reform acting in concert rules, which he's written with Dan Puchniak, Professor of Law at the Yong Pung Hau School of Law at Singapore Management University. So Umakanth, thank you so much for speaking to me today.
Yeah, thanks, Tom. It's really a pleasure to be here. And I'd like to thank you also on behalf of my co-author, Dan Puchniak, for inviting a discussion on our paper.
Yeah, well, I'm very much looking forward to it. And as we only have limited time in these interviews, I'd like to get straight into the meat of your paper. So let's take a few things as given. So let's take it as a given that climate change is a critical social and economic issue. Let's also take it as a given that there's an increasing call for diversified investors, so-called universal owners, to act to mitigate climate change as part of their fiduciary duty to clients and beneficiaries. And let's also take it as a given that collective engagement is one of the most powerful tools that investors potentially have to bring about change in what companies actually do in the real world in relation to climate change. Because then we can come on to really the key point you make in your paper, which is that such climate-related collective engagement, if it moves beyond fairly soft forms of engagement, risks being caught by acting in concert rules that were written for quite a different purpose. And that creates a substantial impediment to more forceful stewardship on this topic. So let's start by taking a brief step back. What is it that acting in concert rules are designed to protect minority investors against?
Yeah. Thanks, Tom. So the acting in concert rules are essentially structured as an anti-abuse mechanism that ensnares certain forms of collaborative action. And I put it predominantly in two contexts. The first one relates to disclosures of substantial shareholding by investors when they acquire large stakes. And that's essentially to minimize information asymmetry, to promote market efficiency, corporate governance, and so on, so that there's a lot of transparency on who's holding how much if they hold significant stakes in companies. So that's one part, which is disclosure, which in our context is less significant for reasons I'll talk about later. The second and most important requirement is in jurisdictions where they do exist, when they relate to mandatory takeovers. And the acting in concert rules basically exist to ensure that if investors come together to acquire control over a company, that minority shareholders have an exit option when they perceive a threat from a new controller. And more importantly, it also provides for an equality of opportunity where those who are acquiring control or would have to also ensure that whatever private benefits of control they are paying to the exiting shareholder controlling the company is also shared with all the other shareholders. So it's largely these two, disclosure and mandatory takeovers, although the concept has also found its way contractually into poison pills and increasingly anti-activist poison pills. That's more contractual, but the first two are more regulatory in nature.
Okay. And so you've made the point that in a number of jurisdictions, these acting in concert rules can get triggered by assertive collective climate action. So what is the stage of escalation or assertiveness at which climate action potentially triggers acting in concert rules? And what are the implications for investors of those rules being triggered?
Yeah. So the first one is we've kind of looked at the laws in a few of the major jurisdictions. And if I can summarize it, I think we can make a distinction between what we call soft engagement and significant engagement. So soft engagement is when there's a dialogue, discussion, potentially even voting actions on particular issues. But the moment it crosses a certain threshold, and that threshold in the study that we've carried out is when there is some kind of a threat of board change or a something that relates to board change composition. That's when there is a real escalation. So usually when we perceive an escalation is if there is an engagement between the investors and the company, and there is either a threat or possibly an execution of a change in board composition. as a means to achieve what the activists want from a climate perspective, that's where things get a little more complicated and the acting in concert rules get invoked. So, in that sense, I think whenever there's a threat of a board change as a means to achieve an end goal that an activist investor is seeking to achieve, that is when there is an escalation. So, anything short of that generally seems to suggest that there is not that much of a concern. But once that threshold is crossed is when there is a question that arises, and what implications it has
Sorry,
on
just
investors.
before getting on to the implications, just to clarify that then a little, just to follow up on that. So is there a distinction here between activist investors just wanting to get a director with climate expertise onto the board, and an activist investor wanting to get a whole slate of directors that potentially change the strategic direction of the company? Is that the sort of distinction that you're talking about here?
Yes, and in most jurisdictions, the change becomes significant when there's a slate of directors being appointed, or pretty much usually a majority of directors.
I see.
I think most jurisdictions are relaxed if there's one director who has climate expertise who needs to be appointed. So I think where there's a question is whether there's a majority of the board being changed or not. Of course, the rules differ from jurisdiction to jurisdiction, but I think the general analysis suggests that it's a majority of the board where the threshold is crossed.
So this is really the case where you've got investors who want to quite assertively change the direction of a company on climate issues. So thank you for that. Sorry, I interrupted you. You were going to just talk about the implications for shareholders.
Yeah. So implications for shareholders, again, goes back to the discussion we had a little earlier about, what are the protections that the acting in concert rules provide. And the implications for shareholders as a whole is that they either are beneficiaries of disclosures, which these investors have to make, or potentially in jurisdictions where the mandatory offer does exist, they become beneficiaries of a mandatory offer, and they get a chance to choose whether they want to remain in the company or not. So I think that's really where the implications arise for shareholders as a whole.
And then, but for the shareholders who are undertaking the action, I mean, these are quite severe consequences, aren't they? So your case is that it's quite an impediment to that action being undertaken.
Yeah. So we do recognize that disclosure is important, but it does not have significant financial consequences, except for the fact that the investors have to come clean with their strategy, and everybody gets to know about it. But I think it's really the mandatory offers that really cause a financial implication, and that we think is much more of a significant impediment.
Right. Yeah. And so because of that, then that creates an incentive for investors to stay well clear of this boundary where they might start triggering these very impactful implications, and therefore they end up getting pushed back into this sort of softer form of engagement rather than the very assertive stewardship. And I think this is why you make the case that collective engagement on climate change should be exempted from acting in concert rules. And in a moment we'll come on to how you propose that should be done. But I guess first I'd like to ask you why you think collective engagement on climate is a special case. Because after all, if investors cause a company to take actions on climate which not all minority investors agree with, and which could be costly to the company financially, why should minority investors not have the same protections they would have in any other situation where a group of investors try to take control?
Yeah. So, Tom, I think I'd like to approach your question in kind of two parts. I think the first part of your question was, why is climate such a special item for discussion? And secondly, how does it affect the rights of minority shareholders? And my co-author, Dan, and I, to be honest, initially, we were actually approaching the issue from a much wider spectrum. We actually were thinking about ESG as a whole. And then we decided that that's kind of a little more uncertain because as we speak, there's so many challenges to the concept of ESG and how difficult it is to cabin that concept and so on. So we thought climate is a lot more straightforward and a clear criterion compared to ESG as a whole. And then, of course, why climate is important, I think others have argued it much better than we have. For example, I think Professor Jeff Gordon has a blog post, and he's been arguing about how climate change is an existential risk that the world is facing. It's an important part of like significant legislative efforts, both domestically and internationally. And most importantly, for our purpose, climate is a material financial risk that has financial implications to the operations of the company. So investors do find it important to be thinking about this. So we then narrowed down our research to climate rather than the wider scope of ESG, which
Yeah,
then brings me to the second. Yes.
Yeah, sorry, I can see that makes sense actually, because this would become much more contentious the broader you go, doesn't it? But sorry, continue, please.
Yeah, thanks. So the second part, I think, which is the more tricky question about, what are the implications of climate activism to minority shareholders? And I think your point is, why should they not be treated on par with other scenarios where acting in concert comes into play? And here, I think we're trying to make a subtle but important distinction between control actions and activism or influence. So on the one hand, we have control shifts, which is where all the disclosure and takeover regulations apply. And on the other hand, you have activism, which is slightly different. And interestingly, this distinction has been also debated in the past in the context of shareholder activism more generally, not necessarily something that involves climate or ESG. For example, more than 10 years ago, Professors Armour and Sheffens, had a paper where they refer to the market for corporate influence as distinguished from the market for corporate control. So the way we think about it is activism involves a single well-defined issue which is at stake, as opposed to control, where there is an involvement by the controller on dominant and ongoing matters of management, which is what controllers seek to obtain. And what we see is it's in the latter cases where there's control shift that there's a need to protect minority shareholders because there's a potential for extraction of private benefits of control and so on, which usually does not occur in the context of activism, unless, of course, the activists have a personal agenda or potential conflicts of interest. But barring those exceptions, which we do need to provide for, activists, are doing something which not only benefits themselves, but also benefits any other shareholder in the company. And we believe that if the shareholders are able to muster enough support in order to push a climate issue before the board, and if they have sufficient majority to overthrow the board, the usual corporate democracy principles of majority rule applies. And what's good for the majority should be good for the minority. So we feel that the acting in concert rule actually comes in the way of exercise of corporate democracy, where the exception that exists, for example, for control shifts are not existing for activism, because we view activism differently from control shifts.
Yeah, I thought that was a really interesting distinction that you made. So if it's agreed that acting in concert rules should be disapplied in cases of climate activism, how do you propose that this should be achieved in practice? And how could we prevent climate activism being used as a Trojan horse for attempts to take control of companies that are driven by other motivations?
Yeah, so I think that's a valid question, and we have to make an intellectual distinction, which I think we're trying to make in the paper. And the more important question you ask is, how can we make the practical distinction in operation? So I think what our paper seeks to make is this distinction between influence and control. So maybe the change in the rules that we are proposing have to make that very clear in terms of what is the distinction between influence and control. And maybe it's necessary to build in certain checks and balances that would prevent backdoor attempts to seek control. So we may have to include what are some examples perhaps in regulations which deal with what is the distinction between influence and control. And maybe we may even want to go to the extent of activist investors expressly disavowing control altogether. So maybe they have to come upfront and say, we are interested only in this issue. We're not interested in controlling the company. So if they do end up seeking a backdoor control over the company, that's a misrepresentation they made to the shareholders. And hopefully the securities law and regulation in different jurisdictions should be able to hold them responsible for that.
Mm. Okay, yeah, interesting. And I mean, it does sound like there are actually broader applications for some of this thinking to be developed as well. The case you make for a substantial role for climate NGOs like the PRI surprised me a bit, actually, because it's not clear to me that these bodies have either the expertise or legitimacy to adjudicate on, whether an approach is an attempt to create control or a bona fide attempt to promote climate action, particularly as they're on very much one side of the debate. Isn't there a risk here that any attempt to introduce such bodies into the process risks being seen as political overreach to try to achieve goals that should really be achieved by public policy?
Yeah, thanks, Tom. So I think our starting point would have been, let investors come together collaboratively by themselves. We don't need to have like an intermediary body. But I think the risk there is the individual preferences and idiosyncrasies of investors would probably dictate the means forward. So there have been some arguments that have been made in the past by authors who say that the presence of an intermediary would provide a level of even-handedness in the process, so that the individual idiosyncrasies can be balanced against each other, so that what ultimately is proposed would be something that is broadly consistent with what's good for all the shareholders. So we feel that maybe in some ways it's probably it's kind of a second best option in the absence of letting individual shareholders deal with it themselves. And interestingly, we discovered through our research, and there's been writings by Professors Tim Bowley and Jennifer Hill in Australia, where there is an express exclusion from the acting in concert rules, so that so long as certain actions have been taken by intermediaries. So there's evidence of that already. So maybe some thought may have already been, undertaken to achieve this kind of an approach. So we are kind of seeking to expand on that. The other important question that you ask is who should be the intermediary? And we've only used PRI as an example. We don't necessarily suggest that it has to be PRI, because in the absence of any other body of sufficient representation, we've just used that as an example. And I think in one way, I think PRI, it's clearly a representative body of institutional investors. It has more than 5,300 signatories with an asset base of over US dollar 121 trillion. So I'm not sure if that would mean that they are necessarily on one side of the debate, because I think it's more about like sustainable investments and so on. So I'm pretty sure that the PRI may be different from like certain activist bodies or activist NGOs, which may adopt a certain different kind of approach. But we do admit that a lot of details need to be worked out. So how will this intermediary represent the investors? Would they take a vote of all the investors on a particular issue? Or what will be the role of the intermediary? Will it be only advisory in nature, like a proxy advisor? Basically, do they tell the investors how they should act, or do they take on a more dominant role, an active role in this approach? So I think where we stand is the goal of our paper is to provide kind of the intellectual framework, but I do admit, based on your question, that I think if this needs to be operationalized, there's a need for more regulatory inputs in the design of the actual mechanism. But we hope that this at least contains like the intellectual framework for further work carried out based on that.
Yeah, well, thanks so much, Umakanth. I thought it was a fascinating paper, and you raised what is obviously a very important issue, but which would also be complex to resolve, given that it's sort of jurisdiction by jurisdiction. So plenty of work ahead to make progress on this. But thanks so much for your time sharing your thoughts with us today.
Yeah, sure. Thanks, Tom, for having us on this.